Mr. Siminya.
Good morning, Chair and Commissioners. This morning we have Ms. Mabule joining us for passage of motion.
Thank you. Advocate Mabule, you are reminded that you are still under your former oath.
Thank you, Commissioner.
Mr. Vani.
As the chairperson pleases, Ms. Mabule, do you prefer to be referred to as Advocate Mabule or Ms. Mabule? Sorry?
Ms. Mabule.
Okay, Ms. Mabule. Firstly, thank you for coming back. I know it's an interruption in your schedule, but we are grateful that you have made the time this morning. We also appreciate that you struggle with your eyesight. And I understand that an arrangement has been made with the Commission that where you need a document projected, it'll be displayed on the screen for you to read in case you're unable to read the paper work in front of you. So we will endeavour to assist, and we'll give page numbers to our colleague who will then project the relevant pages on the screen to the extent necessary.
Thank you.
Commissioners, I should have checked, is that in order with the Commission?
That's in order.
Thank you. Now, we appreciate that the events we wish to explore with you happened a long time ago. And we also appreciate, Ms. Mabule, that you found yourself in a position that was not of your own making. So we just place that on the record. We have given you our questions in advance, and we've hoped that you had an opportunity to look at them and to revisit the documentation before today. So let's then commence. According to your evidence and records before this Commission, you were a member of both the Amnesty Task Team and in the subsequent Interdepartmental Task Team. We sometimes refer to them as ATT and ITT. Would I be correct in saying that you were asked to attend the Amnesty Task Team meeting? You have explained that you attended in place of your superior because he wasn't able to attend. But would I be correct in saying that you were asked to attend because you were a legal advisor to NIA at that time?
Correct, Advocate Vani, except to say that I was never a member of the ATT. I had a 15 to 20 minute stint, as already alluded to, in that committee.
Thank you.
Yeah.
And yes,
look at the chair when you talk, ma'am, please.
Thank you, Commissioner. I just wanted to hear the advocate correctly.
Okay.
Thank you.
Yes, when I'm talking, you're free to look at me, but in your response, if you could direct your words to the chairperson and the commissioners.
I will.
Thank you. So you mentioned that your involvement in the ATT was 10 to 20 minutes, and it's apparent from your statement as well as your evidence in chief that by the time you arrived, the meeting had adjourned, and that you simply could only speak to some of the people before they left. Is
The
that correct?
meeting had not adjourned. The meeting was about, they were wrapping up, the meeting was about to adjourn. Like I indicated, it was about 15 to 20 minutes to. That is why I was even given a document that I indicated that I handed to Mr. Mavimbela, on whose behalf I was attending the meeting.
Right. Do you have any explanation or idea why your name appears on the attendance list of of both meetings?
Yes, I do. I attended the meeting, be it for 20 minutes. I was there. They registered my presence.
Now, in the 10 to 15 or whatever minutes before the adjournment, do you have a recollection of what was being discussed in the time that you were present?
I can't remember quite honestly as to what was discussed because of the fact that I don't even know how long the meeting had been sitting. But however, the issue was around the TRC as to how best can they approach the TRC. They distributed those forms or whatever documents that I handed over to Mr. Mavimbela. I'll be lying to say that I heard what was discussed, or maybe the terms of reference and everything that was discussed in the meeting I didn't hear.
And the documents that you were given, which you subsequently handed over to Mr. Mavimbela, the Director General, what was in those documents? Do you recall the contents?
I didn't read the document. I handed the document to Mr. Mavimbela.
Can I ask why you didn't read them?
It was not my meeting. It was Mr. Mavimbela's meeting. So I gave the document to him. And he never asked me to.
And then subsequent to that, I assume you've had an opportunity to look at the reports, the two reports of the Amnesty Task Team. Is that correct?
There's one report that my evidence leader showed me. It was for the first time that I laid my eyes on it. I can't remember even what was it all about. Because I was not a member, there's a need to know principle within the intelligence community. So the fact that I attended the meeting of the ATT once doesn't make me a member, or doesn't expose me to what their discussions was. And if I may explain something, Advocate,
Please.
the ATT was for the head of department. I was not a head of department. I was just asked to go and represent Mr. Mavimbela. So they've got their own meeting.
But in your preparation for today, can I assume that you perused the two reports of the ATT?
I didn't peruse them. They were delivered to me yesterday. The font is so minute, it challenged my vision.
Okay.
They were delivered yesterday early evening.
Well, we do have some questions arising from those reports, and to the extent necessary, we will put them on the screen. Do you know why those reports were classified as secret?
I wouldn't know.
Okay.
But from what I saw when they were projected, it's a Department of Justice document. Maybe the head of the Justice Department can better answer to that.
Thank you. Then, in the first report, and Chairperson, the first report is from page 17 of the bundle. I beg your pardon, it's from page 8.
Advocate Bani, did you see the size of the font? I should think even you able to vision.
Yes, it is small. That is beyond the control. That's how the documents were provided to us. I must say, I even struggled to read it with my Clicks reading glasses.
Not only small, but faint as well.
Faint, yes.
Yes. I will read into the record the aspects that we would like her comment on. And we'll try to keep it brief. So, at paragraph 3.2.4 of that report, the ATT records a concern that they had that the initiative could result in the possible negation of constitutional rights.
I beg your pardon?
Let me read it. So on page 16, maybe my colleague can try and put page 16 onto the screen. And if you can make it as big as possible, and we'll read from paragraph 3.2.4. The task team realizes that the proposed process will have the following shortcomings / concerns. A possible negation of the constitutional rights of victims, the public at large, and alleged offenders. Can I ask whether you know why the ATT expressed that concern?
I wouldn't know. I wasn't part of the meeting. Really, advocate with the greatest humility. I should think to throw me onto the ATT's meetings and what they envisaged. It's a bit unfair because I've never become a meeting. I don't know why we're discussing this and for what purpose and what were their intentions.
Yes. Well, I understand where you're coming from. From our perspective, the reports reflect you as a member of the ATT, and you were a legal advisor for the NEA at the time, and we had assumed that you would have taken a look at these documents before coming here today.
I was never a member of the ATT. It was kept secret. I don't even know at what times they convened. And even if I could read here, which really it will be to surmise before this court, trying to really figure out what were they trying to achieve.
All right. I want to draw your attention to the fact that following the first meeting of the ATT, that first meeting was on 26 February 2004. The representatives of the NPA reported to the then NDPP advocate Bulelani in Guka. And when NDPP in Guka learned that the ATT was developing new criteria for the TRC cases, according to his evidence, he immediately instructed his team members to cease participation in the process. And the reason he gave was that, firstly, he did not agree with the proposals, and secondly, he said that there were persons in that meeting concerned about the ANC 37 case, and that could compromise the NPA. Can I ask for your comment on the fact that the NPA decided to withdraw its members for that reason after the first meeting?
I wouldn't know. I don't know. I wouldn't know why Advocate Bulelani would do that. It should have emanated maybe from their interaction as head of department.
But as a former legal advisor for NEA, can you understand why NDPP in Guka took that position?
I'm not exposed to the facts, so I don't want, like I've said, I don't want to surmise before the commission, because I should think that was based on the facts.
Yes, and I did put the fact to you as he put it to this commission.
That is just a resolution. When Advocate Bulelan decided to withdraw, so I wouldn't really, like I've indicated, please advocate, I was never a member of the ATT. There's a high-leveled structure of the heads of department. It was never even my ambition to be at that level.
Yes, and that's why I preface my questions with recognizing that you were in a position that was not of your own making. So we do appreciate that. But the fact remains, Ms. Mabula, that you were a legal advisor to NIA. And the report does raise some worrying aspects that we do seek your view on. So, for example, following that first meeting, the heads of department had a meeting with the ATT, and I'm assuming that you were not present at that meeting. Is that correct?
Correct. I've never thereafter attended any meeting, nor briefed of any meeting of the ATT.
Then, you know, as a legal advisor to NIA, I want your comment on the instructions that the departmental heads gave to the ATT. They asked the ATT to further consider certain aspects. One was whether there was a way in which private prosecutions and civil litigation could be eliminated if the NDPP decides not to prosecute.
That's not within my purview, but however, I've always regarded prosecutions to be within the mandate of the Department of Justice. So I really, like I said, I'll be surmising, which I don't want to, before the commission.
So-
Maybe, if I may, Chairperson, apologies, Mr. Vani, and Commissioners.
Switch on the second microphone as well, please.
Me,
If I may, Chairperson and the Commissioners, the witness has stated categorically that she was not a member of ATT, and she has no knowledge of the issues arising from the ATT. Perhaps Mr. Vani could cease with
Yes.
that line of questioning.
Yes. She is being asked as a legal advisor of NIA whether she had knowledge of the report. Yes, Mr. Vani?
Thank
Mr.
you.
Vani, you do realize that Ms. Mabule has already conceded to the fact that she was not a member. She was present at the ATT's meeting towards the final stages, but she was not privy to the discussions that were discussed there, nor was she privy to the report that was subsequently made in respect of that meeting. You do appreciate that.
Yes,
But
Chairperson.
you want her knowledge as a legal advisor of NIA
Yes, indeed,
with
Chairperson.
regard to the report.
That's correct, Chairperson.
And
That's-
that is if that report was brought to her as a legal advisor.
That's
Yes.
the context in which we
Yes.
are attempting to pose the question, Chairperson. We just wish to place on record, Ms. Mabula, that, and if I can draw your attention to page 8 of the bundle, and perhaps my learned friend for the Commission can put that on the screen. We can go to the bottom of page 8.
it's the faintest font.
It is the faintest font, but we're going to put it on the screen and enlarge it. And if we could just go down to 1.2. So if you can just stop there for a moment. 1.2 reflects the following members, and as you can see, you're reflected as one member. Then 1.3, the task team was requested to submit its report to the Director General's Forum. We don't have to go into those details, but we can just scroll down to the next page at the top. And if we can just stop at the top there. It says Commissioner Ray Lala could unfortunately not attend the first meeting. He did, however, submit his proposals to the task team for its consideration. So the report does reflect somebody who wasn't able to make it. But as you can see, your name doesn't appear as somebody who couldn't make it, possibly because you came some minutes before the end. But we just place on record, Ms. Mabula, that the report does indicate when people are not there.
Yes, Raymond Lala could not appear. Raymond Lala was part of the meeting. I should think whatever concerns or whatever was supposed to be done, they should have directed it to Mr. Mavimbela. Maybe if Mr. Mavimbela can appear before this commission, will better articulate to that as to what transpired afterwards. But however, Mr. Mavimbela did leave shortly afterwards. The period came to an end. Another DG was appointed who also was for a short stint and has since passed away. Then Mr. Mazini attended the meetings and has passed on as well. But however, there was continuation, I suppose, of people who should have attended this.
So the report also makes reference to a proposal to establish an interministerial committee to oversee these TRC cases. And we do know that a cabinet committee on post-TRC matters was subsequently established under the Justice, Crime Prevention and Security cluster. Would you be aware whether that subcommittee in that cluster had its roots in the proposal of the ATT?
I wouldn't.
And then lastly, before we move to the ITT, now the ATT made certain recommendations, some of which were implemented. And again, I'm asking for your comment on these recommendations, given that at the time you were legal advisor to NIA, and I accept that at that time you might not have been aware of these recommendations, but nonetheless I seek your comment on them. And I'm going to summarize the recommendations so we don't have to read them, but I can give you the references if you need them. The first one was to devise new prosecution criteria.
Where are you reading from?
I'm actually looking at the cross-examination application. Commissioner Como, that's on page 5 of the bundle, at paragraph 11.10.
Thank you.
So the high-level summary is one, to devise new prosecution criteria for the NPA's prosecution policy that would apply exclusively to the TRC cases, to provide additional criteria not to prosecute those cases. And then the second main recommendation was to create a departmental task team and that this group would advise the NDPP on the desirability of prosecutions in the TRC cases before a decision is made in each individual case. Now, as a legal advisor, do you have a comment on those recommendations?
I can say that there's what we call a security cluster, and security cluster met and other forums around that. They will meet regularly to discuss matters of overlap and how collectively and efficiently they could execute their mandate to secure the security of the country and to support each other in their line of duty.
Let me put to you the submissions that we intend to make this to this commission. That the recommendations of the ATT were aimed at creating avenues for apartheid-era perpetrators to evade justice.
I beg your pardon, I can't hear.
I'll repeat that. I want to put it to you what the families will be submitting to the Commission on those recommendations. One, that they were aimed at creating avenues for apartheid-era perpetrators to escape justice. And secondly, that they were unlawful and unconstitutional and amounted to interference with the independence and authority of the NPA to pursue the TRC cases. Would you agree?
That's how they saw it based on what was presented to them. I wouldn't fault them. Maybe they were exposed to documents, to information that made them come to that conclusion.
No, it's simply based on the content of the recommendations, some of which were implemented.
I'm not exposed to those recommendations except the ones that you've just read to me now. That's why I'm saying that what you have read to me now, yes, there were security clusters that used to meet and discuss that. I was not part of those security clusters. They were high-leveled. So if ever the families feel that way, I won't blame them. They might have been exposed to other documents that I'm not exposed to or other information that I'm not exposed to.
Yes, so we've moved on from the security cluster, and we're only relying on the documents that are in the bundle, nothing more. Let's move to the Interdepartmental Task Team, the ITT. And here I think you're in a better position to deal with questions as you were present at those meetings. So you're aware that this body was set up following the promulgation of the new guidelines, the amendments to the prosecution policy, and the body was set up during the course of 2006, and that there were various members of the executive on that body, including the National Intelligence Agency, NIA, and I understand that you were one of two representatives on that body. Is that correct?
Yes.
May I ask, why was it necessary, in your view, for NIA to be involved in the ITT, which effectively was a case-by-case management of the TRC cases, when SAPS already had an intelligence capacity in its crime intelligence division?
Advocate, my name was nominated to this committee, and my view here is that we were aware of the fact that there is an intelligence unit within the SAPS, but however, they thought that they could rely, because NIA has got archives of former intelligence or security police activities. That's what they thought, that we could help as the process goes on by going back to our masters and indicate as to whether they search for this type of information, or from the operational division, maybe they could help in assisting the prosecution to get to the core of their mandate.
Thank you. That is useful background. And can I ask you to speak to the role of NIA on the ITT, and in particular whether NIA provided any information or intelligence or risk analysis to the ITT?
By the time I left, that had not yet taken place, because I never stayed for long. That's when that I assumed my functions as the principal officer of the medical aid scheme. My colleague, maybe, I don't know whether will remember, because this is quite some time back. We had not yet received many documents that could allow us to go back to the intelligence to be able to assist. If that has happened, maybe Mr. Khampepe could indicate before the commission.
When you left, can you remind us when you left?
Commissioner?
You say when you left, but I say, can you remind us when you left?
2026 January. I attended about 3 meetings, which I said I could not remember those meetings, the participation. Nothing has as yet, because they had just started, nothing has as yet taken place.
Yes, thank you.
Thank you, Commissioner. And yes, we have asked the Commission to make contact with Mr. Brian Khampepe. So in fact, the ITT was only in existence for a few months. It first met in October 2006, and its last meeting was in the last week of January 2007. So it seems that in fact you were actually present during its full period of operation. But as I understand it, between October 2006 and January, the last week of January 2007, the NIA didn't provide any intelligence or risk analysis in that period?
No.
Thank you. And the respective roles that you and Mr. Brian Khampepe played on the ITT, was there some kind of division of responsibility?
There wasn't any division of the responsibility, except to say that Mr. Khampepe came from NCC, I was from NIA. We were there for basically the same reason.
I see. And I think I know what NCC is, but for the benefit of all of us, can you explain what NCC stands for and what role they played?
It's part of the intelligence community, it's the National Communications Center.
And the National Communications Center, and excuse my ignorance, was that like a public relations body, or did it have some intelligence function as well?
It has some intelligence functions.
Thank you. I want to refer you to the minutes of the ITT meeting that took place on the 12th of October 2006. And the passage that I want to refer to is at page 55. And maybe we can throw up page 55 on the screen. Perhaps we can start at just page 54 just to locate ourselves. At the top, thank you. So as we can see, this is the minutes of TRC committee meeting 12 October 2006. And your name appears at number 12, representing NEA, and at number 9 is Mr. Brian Khampepe, also representing NEA. Let's then turn to the next page. And under the heading Committee Meeting, and perhaps I'll just read into the record that paragraph. Dr. Ramaita requested PCLU and SABC to compile an audit report of all cases in their possession, and that the PCLU will take charge of investigations being assisted by SABC. The committee will then deal with all cases, including matters that have been closed by the PCLU. Mr. Ngidi, and I believe that Mr. Ngidi was from, and we'll just check. Mr. Ngidi was from the DSO, also known as the Scorpions at that time. Mr. Ngidi indicated that committee members will not be rubber stamp. I think it should be will not be rubber stampers to decisions already made by the PCLU. And he was supported by Mr. Khampepe. He said they are prepared to go through volumes of records in all cases. Since Mr. Khampepe, on behalf of NEA, was saying that NEA would not rubber stamp the decisions of the PCLU, can I ask you to elaborate on that? What did it mean by not rubber stamping decisions of the PCLU?
You know, this took place a long time. I can't remember the deliberations, but if she says you can't rubber stamp the mandate of the PCLU, it's because of the fact that that's their function to prosecute TRC cases. And however, there wasn't much that was exposed to the meetings by the PCLU. So that's why it was decided that there should be cases that on which even us NEA could work upon to go and verify as to whether we could be of assistance or not. But as to how Mr. Khampepe came to this, I can't remember quite well, but that's my assumption.
Would I be correct in saying that the impression gained is that because you wouldn't simply be rubber stamping, you wouldn't take decisions of the PCLU at face value, you would want to be satisfied with those decisions, and you would want to look at all the relevant documentation?
Yes, I mean, as a lawyer, you can't just thumbsuck what the issues are. You should be exposed to the documents, we should be given the documents, read through them so that you can make a meaningful input in the meeting.
My attention has been drawn to the ITT minutes of the 16th of November 2006. Now, unfortunately, I'm advised that that particular minute is not in this meeting.
In this bundle.
Sorry, is not in this bundle. I beg your pardon, Chairperson. But with the Chairperson's leave, I'd like to read a paragraph from those minutes.
Yes, you may.
So we're dealing with the minutes of the meeting on the 16th of November 2006. And you was also present at that meeting. And the extract reads as follows. Yvonne raised a concern on identifying matters to utilize NEA on security aspects, but agreed that on completion of investigations and receipt of representations from perpetrators, such could be dealt with depending on the circumstances of the cases. Do you recall raising that?
Can you say that again?
Yes,
I'm
of
sorry,
course.
I can't read them.
Yes, as mentioned, unfortunately this is not in the current bundle, so I'm reading from the minutes of the ITT meeting of 16 November 2006, and I'm going to read slowly. Yvonne raised a concern on identifying matters to utilize NIA on security aspects, but agreed that on completion of investigations and receipt of representations from perpetrators, such could be dealt with depending on the circumstances of the cases.
Yes. We were not yet exposed to a value within that meeting. There were no documents that were given. We came as we were with the aim of getting documents before the ITT to be distributed by the Department of Justice. So such documents were never exposed in my presence there. And I said that, if I remember quite well, that we have not yet been exposed to the documents on which NIA can be of value and assist the process. And that after that has been done, then the prosecution will continue. If ever we've brought certain value or whatever, we couldn't, but however, it's still the mandate of the prosecution to continue with their mandate to prosecute those who are supposed to be prosecuted for the TRC cases.
Thanks for that clarification. And when you refer to receipt of representations from perpetrators, would I be correct in saying that you were referring to the envisaged process whereby perpetrators would approach the committee in order to apply for consideration of an application to, or rather for the NPA not to prosecute them, applying the new criteria, and that NIA would then look at those representations and make its inputs?
Advocate Van, my presence being there was to assist in the prosecution of the perpetrators of the TRC Commission who never received amnesty. And those dockets was within the domain of the PCLU and the Department of Justice, NPA. So
Yes.
not the ones that were going to appear to request that the amnesty be extended.
Yes, no, we're not talking about amnesty. The guidelines didn't provide for an amnesty. They merely provided for new criteria upon which decisions would be made, in particular decisions not to prosecute, and that perpetrators could approach the NPA in that regard. So my question is, when you refer to receipt of representations, I'm assuming that these were the kinds of representations you expected to consider.
No.
So then what did you mean?
What we envisaged was, because there was SABC, there was PCLU, there was NPA, the committee was just to look at and prioritize cases for prosecution. Not the people who will be approaching that committee. Even that committee was the lowest in the food chain to take such decisions.
So when, just to be clear, when you refer to the receipt of representations by perpetrators, what actually were you referring to?
Statements that were taken as and when they were identified for prosecution, because some are made to understand did face prosecution, we've seen on TV. Not to request that they not be prosecuted. That was not the correct forum, I suppose, to approach.
Okay, well,
The ATT was to look at information dockets. That is why we requested that we be finished with those dockets so that we can assist.
So your recollection is that when you referred to representations, you were referring to statements that
Exactly.
the investigators had taken and were in the relevant dockets.
Exactly.
So I think there's a misunderstanding between ourselves and yourself, because our understanding is that the representations were in relation to the new criteria, and it effectively was a request for the NPA to consider their representations in light of the new criteria. And so I need to put it to you that those were the representations, and that you weren't referring to statements in the dockets, you were referring to their representations.
Mr.
I'm sorry,
Van,
Commissioner. My apologies. I thought I've switched it off.
yes. Mr. Vani, in other words, representations from so-called perpetrators not to be prosecuted.
Exactly, in terms of the guidelines or the amendments in the prosecution policy.
Yes, okay.
Perhaps just to remind you of the question.
Sorry, my apologies. My two apologies.
Thanks, Ms. Mabula. So we put it to you, Ms. Mabula, that the representations you're referring to in that paragraph were not the statements in the docket taken by the investigating officers, but were rather representations to be made by perpetrators who were seeking a decision not to prosecute in terms of the new criteria.
I never understood that to be part of the mandate of the ITT. The ITT was to look at the prosecution.
Yes. Well, we need to put it to you that you're mistaken in that regard.
I
You
was
have
there.
a response, Mr. Vani.
Yes. Let's move on. Now, I want to draw your attention to a letter from then Commissioner Selebi to the then Director General. It's in the bundle at page 39. This is a letter, it's dated 6 February 2007. It's from the National Commissioner, Jackie Selebi. It's addressed to Mr. M. Manzini, Director General, National Intelligence Agency. It's titled Outstanding TRC Cases. I'm going to read portions of this letter into the record, and I thank my colleague for putting it on the screen. You can also follow it on the screen, and I hope you can read it. And I should say that the same letter, the exact same letter, was also addressed to Advocate Pakoli, then NDPP, as well as Advocate Menzi Samalani, then Director General of the Department of Justice. It reads, I have been briefed on the last meeting of the task team set up in terms of the Cabinet guidelines on outstanding TRC matters. It was brought to my attention that in SV Otto, the complainant Rev F. Chakani, a decision on prosecution was taken without consultation with the respective departments. I have insisted that the complainant be consulted in terms of the guidelines on the basis that the Director General will have an opportunity to provide input before a decision on prosecution is taken. I'm also under the impression that there's no common understanding on the process to be followed. My understanding was that the officials designated on the task team by the Directors General will provide recommendations to the Directors General, who will, as a collective, advise the NPA as the decision maker on prosecutions. And then if we can turn to the next page, that's page 40 of the bundle. In my view, a comprehensive report, such as the one directed to the NPA, dated 24 November 2006 and revised on 24 November 2006, should be discussed by the Directors General. Although I do not insist on a meeting of the Directors General, after each meeting of our officials, I deem it necessary that the substantive reports and recommendations of the officials should be discussed by the Directors General before a decision is made. I'll pause over there. Now, essentially what Commissioner Salebi is saying is that before the NPA can make a decision in each individual TRC case, it must hear from the Directors General so that they can consider the matter properly and provide a recommendation. Now, I need to also tell you that the NIA concurred or agreed with the letter of Commissioner Salebi. And just to demonstrate that, I want to take you to the memorandum of Advocate Pekoli at page 50 of the bundle. Perhaps if we can just start at page 43 and let's just be clear about what document we're dealing with. If you can put it on the screen, please. Thank you. So this is a secret internal memo from Advocate Pekoli, NDPP, addressed to the then Minister of Justice, Ms. Mabandla. It's dated 15 February 2007. And if we can then turn to page 50. To save time, I'm not going to deal with all the preceding paragraphs of 4.43, but essentially what Advocate Pekoli does in those paragraphs is to describe the communication that we've just been through. And if I can draw your attention to the bottom of that page in paragraph 4.4.3, and I'm just going to read the relevant line. The Director General NIA indicates that he had a discussion with his representative on the task team and he received a copy of the National Commissioner's letter. He concurs with the views of the National Commissioner. So we have confirmation from Advocate Pekoli that NIA agreed with Commissioner Salebi that the NPA had to hold back for this recommendation before it could take decisions. May I ask, why did NIA agree with Commissioner Salebi on this issue?
Advocate Vani, I wouldn't know. I'm listening to you reading this. These are the minutes of the heads of department. And I should think this was not just an isolated meeting. They have been deliberating these issues at a higher level, maybe taking instructions from whoever. So, and there is an overlap of mandates and so forth. I wouldn't know as to why Mr. Manzini agreed with Mr. Salebi. Maybe that is based on what they were discussing as heads of department.
And
But from where I'm sitting, we are dictated by law as to how and to prosecute, decisions to make. So I don't know what were they deriving their input as to come up with that particular recommendation.
What meeting is that?
I'm a creature of statute.
Now, according to Advocate Bakuli, the Director General Nia had a discussion with his representative on the task team. Were you that representative?
To which task team?
The-
I don't hear him, Mr. Manzini, indicating which task team, because there were several task teams running at that particular
Yes, it's the
moment.
same task team we're talking about, the interdepartmental task team.
I don't know where he took that from.
Chairperson, I see it's 11 a.m. Would this be an
Yes.
appropriate time for the tea adjournment?
Yes, how long do you still need to have Mr. Vani?
We are not going to be particularly long, Chairperson, but we do want to put one other minute before the witness. And regrettably, I'm advised that that ITT minute is not in the bundle, for which we apologize. It's only one page, so we want to make a copy to distribute to everybody.
So you'd like to have an opportunity to be able to make such a copy?
If the Commission pleases.
It is not for tea, it is for your own convenience.
It is for our own convenience, but it coincides with tea time.
Yes. We'll take a tea adjournment until 11:15.
Just tell me, yeah, I know.
Thank you, Mr. Vani.
Chairperson, we are grateful for the indulgence and we apologize for the interruption. Commissioners, we have circulated a copy of the minutes of the task team meeting held on the 29th of January 2007. We should point out that Ms. Mabula herself annexed the minutes of this meeting to her statement as YM1. We should have attached it to the bundle as well, and for that we apologize. I have asked our friend controlling the laptop to put up on the screen the minutes of this meeting. So, Ms. Mabula, let's just look at the heading. It's titled Minutes of Task Team Meeting, 29 January 2007. This was, in fact, the last meeting of the ITT. You'll notice from the members present that both yourself and Brian Kupedi are listed under the heading Members Present. Now, I want to draw your attention to the third and fourth paragraphs, and I think it might help if I read them into the record. Advocate Ackerman SC requested members for their inputs with a view to finalize the draft report to be submitted to the National Director. Commissioner Jacobs indicated that he was made to understand that Rev Chikani was not interested in the prosecution of the accused in his case. Therefore, he needs to be consulted, and the matter needs to be discussed with their principals before making recommendations. Next paragraph. Advocate Ackerman SC reminded the meeting that the National Director has made his decision on the matter. Yvonne concurred with Commissioner Jacobs on Reverend Chikani's matter. That's where I'll pause. So essentially what we want to draw your attention to is the last line of that third paragraph, because that's where Commissioner Jacobs says that the matter needs to be discussed with their principals before making recommendations. And then in the next paragraph, it's reflected that you concurred with Commissioner Jacobs. So it does seem as if you did agree with the procedure mentioned by Commissioner Jacobs, which was then subsequently reflected in the letter from Commissioner Salebi. Would you accept that?
I'm still trying to read. Yes, it might have happened.
Yes. So it might have been, we don't know, but it might have been that you were the representative that Director General Manzini spoke to.
No. I was not within General Manzini's direct department. I was at the National Intelligence Agency. Director Manzini was at the NCC. Later on, after Mr. Masetla was removed, is then that came on at a later stage.
Right.
So I don't remember that I could concur with Mr. Manzini, or I ever gave Mr. Manzini a report. I never gave a written report of the ITT as yet to the department.
Thanks for that clarification. But it remains that yourself, the Director General, and Nia were on the same page, that you agreed with the proposed procedure of Commissioner Salebi.
What was that of Commissioner Salebi?
Essentially that before the MPA makes a decision, it must wait for a recommendation from the Directors General.
Of Justice.
Well, the Directors General, the principals, from what we can ascertain, the ATT would advise the Directors General, who would then make a recommendation to the NDPP.
No, the ATT was getting their mandate from the Director Generals. But however, it was led by the NPA and SABS. SABS were in the investigating department, and NPA was the prosecuting department. I thought you mean the issue of Reverend Chikane, because it was a cold fact even in the media that had pardoned the perpetrators, people who had poisoned him. But however, other departments still wanted to proceed with the prosecution, others didn't want to. So I don't remember, I never gave Mr. Manzini, can also check with the report. I've never given Mr. Manzini any report.
Yes, so the Chikane matter prompted the concerns raised, but the procedure proposed by Commissioner Salebi would have applied in all TRC cases.
I don't know, I wouldn't know.
So I want to, as my final question, I want to put to you the response.
Are you moving away from this document?
Yes, I'm about to, Commissioner, but if you wish to intervene, please do so.
Yeah, it's just on something that irks me. I see the person who took the minutes, everyone is Dr. So-and-so, Mr. Ngidi and whatnot. When it comes to you, it's just Yvonne.
Yes.
It's condescending. Did you take them to task why they...
After this meeting, I was at OPMED.
Sorry?
I never saw this, the contents of this minutes, because the 1st of April, I assumed my duty as a principal officer of the medical aid scheme.
Yeah, I think it's really condescending. It irks me. It's because perhaps you're the only woman there, so you're just Yvonne, not even Miss Mabule. Yes, you may continue.
Commissioner, we agree that that is regrettable indeed. Ms. Mabule, I want to put to you the response of Advocate Pekoli to this proposed procedure, and it's reflected in the document that we have already referred to, and that's at page 43 of the bundle. Perhaps it can be put on the screen as well. It's the secret internal memorandum that we consulted before tea time. It's addressed from Advocate Pekoli, then NDPP, to the then Minister of Justice, Ms. Mabandla, dated 15 February 2007. It's on the screen now. And can I ask you to jump to page 52, paragraph 5. Yes, that's it. If you can just pause over there. I'm going to read this into the record and then pose a question to you. It's under the heading Conclusion and Way Forward, 5.1. There is clearly a misunderstanding regarding the role of the task team and the role of the relevant state departments referred to in the amended prosecution policy. In accordance with the approved amended prosecution policy, the NPA is of the view that the duty of the task team or the relevant state departments is to assist the NPA in the execution of its duties. However, nothing prevents such a task team or departments, whether individually or collectively, to make recommendations to the National Director, provided that the National Director should never be in a position where his constitutional duty is dependent on the recommendation of such a task team or relevant department. Such a procedure would be unconstitutional. Do you agree with the objections of Advocate Pekoli?
Yes, under normal circumstances, yes, we are not the prosecuting authority. We were not the prosecuting authority. We were assisting, as I've already alluded to, that ours was just to assist as a collective and as legal representative from the different departments as to how best to carry the mandate forward of prosecuting those people that were never given amnesty.
Thank you. And would you also agree that Mr. Selebi's Commissioner Selebi's insistence that the NDPP wait for a recommendation in each case, that would be unconstitutional?
I wouldn't put myself in that position, because here were two heads of department. I would say there were some overlaps. That was also a cause of some misunderstanding. So I wouldn't say I agree with Advocate Piccoli, Commissioner Selebi, because I don't know what Commissioner Selebi was basing his argument on.
Thank you, Ms. Mabule. No further questions, Chairperson.
Thank you, Mr. Vani.
Ms. Mabule, I'm over here.
Thank you.
I just want to go back to the ITT, and you were taken through the minutes of those meetings. And you were taken to page 55. It's the, it's really what Mr. Kupedi said. And maybe it's unfair that I ask you for an explanation, but let's see what you can remember. You were referred to the last two lines.
What was that?
Well, let's read the last sentence. Mr. Ngidi indicated that the committee members will not be rubber stampers to decisions already made by the PCLU. And he was supported by Mr. Kupedi, who said they are prepared to go through volumes of records in all cases. Now, in your evidence today, you indicated that that would include statements in the dockets. Did I understand you correctly?
Statements by the respective perpetrators, people who were supposed to be prosecuted.
Statements by the perpetrators.
Yes.
And so what role would the NIA play once it received those statements by the perpetrators?
You know, there were challenges whereby they could not trace some of the perpetrators, whereby sometimes they didn't know what happened, but they wanted to investigate the death and so, and there were people who were implicated who could not admit that they did do those deeds. So NIA, which is the former NIS, their function mostly will have been to go on to their archives, which were destroyed, of course, to go into the archives, to use their operatives to try and help as to whether they could come up with evidence as to how those people died and how best they can formulate the evidence. Commissioner, intelligence collects intelligence, and intelligence is not evidence. So if ever you've collected intelligence, which might have been collected by our operatives, it will have been given to the respective prosecuting authority to follow it up and make sure that they take out evidence out of that, in particular intelligence that could be admissible, because intelligence is not admissible before a court of law.
Okay. And when Mr. Kupedi refers through volumes of records in all cases, I assume that that means more than just statements from the perpetrators. What else would it include?
You know what? I was trying to grab my mind, to scratch my mind, because really, honestly, I don't remember most of the things.
Yes.
But the issue was we could not just sit in the meetings as decorative ornaments. We would like to know what is it that we are advising upon. Give us the documents. We're legal people. Let's advise you as to whether maybe this is worthy of prosecution or further investigation or not. There was also subs to that function. So it was based on that the Troika principle of Scorpion still applied at that time. So there were many stakeholders that were in that particular meeting, and sometimes there were clashes. I wouldn't just be seen to be advising on something that I don't know, on hearsay. I wanted something that is under oath, something that I can really say that this is a legal document and I can give my opinion on it.
Would that include statements of the victims in the docket?
Yes, everything.
Everything in the docket?
Yes.
So effectively, it meant that you required the entire docket?
We didn't require a docket.
Okay.
We required certain documents because the dockets, I wouldn't want a docket myself, a whole docket myself. I trusted that the people with the NPA knew what they were doing. SABC knew what they were doing. But however, if ever they want our collective advice, they should expose us to those documents that are sacrosanct to the decision making, whether to prosecute and which cases to prioritize and based on what.
So the role of the ITT was, if I understand you correctly, to analyze what was in the dockets and to provide advice on whether to prosecute or not, or whether to prioritize or not.
To analyze the documents that were given by NPA and SABC.
And SABC. So that would include the information available to the prosecution team.
Yes.
And what had been uncovered by SABC.
Yes, they were uncomfortable to sharing documents, but however, for as long as we could get documents which will really put us into good purpose in that meeting, to be able to assist.
Okay, thank you very much.
Ms. Mabule, we thank you. Oh, resignation, Ms. Semen.
I was going to object.
I dare say that there are no questions for
Yes,
examination.
yes, thank you for having come to my rescue before an objection was raised by my colleague. Ms. Mabule, we thank you for having come to give evidence before this commission.
Thank you.
We wish you a speedy recovery with your eyesight, and you are excused now as a witness.
Thank you, commissioners. Thank you.
Mr. Siminya?
The hearings are to be postponed until the 24th.
24th. Yes.
Chairperson, we thought that there were witnesses for tomorrow. We understand that those witnesses have been postponed.
Mr. Siminya?
Chair, the answer is yes.
Both microphones, please, Councillor.
Thank you, Commissioner. Yes, the matters for hearing tomorrow cannot happen because the scheduled witnesses would prefer to come at a time different from our schedule. So we are now going to be trying to find a mutually convenient time for all parties, shall I say, when that evidence will be
Yes.
brought.
But this should have been communicated to all the parties.
Yes, I concede. Yes, I concede, Chair.
Yes. These proceedings are agenda. Yes.
Chairperson,
Mr. Vani.
sorry to interrupt. We just have a small housekeeping matter. We did write some weeks back to the Commission to advise that I will have to participate remotely because
Yes.
from Monday for 2 weeks I have to
Yes.
attend to childcare duties abroad, but I will be online remotely, Chair.
Yes. It is noted, Mr. Vani.
Thank you, Chairperson.
Thank you. Yes, Mr. Siminya?
Shall we then postpone the hearings to Monday, Chair?
Yes. These proceedings are adjourned until Monday, the 24th of August at 10 o'clock.